Hello, everyone, and welcome to the first presentation in our series of our international webinar series talking about international employment issues. Thank you for joining us today. I'm Devan Khagram. I'll be chairing today's session. Firstly, I'd like to start with a few housekeeping points. Please note that participant video and audio has been turned off. The session is recorded, and that recording will be made available later. And we will have time for Q&A at the end. So please, if you have questions, there's a Q&A tab at the bottom of your Zoom link. Please do put your questions in there. Please do add your name, because in case we don't get time to get round to all the questions, we can always follow up with you afterwards. So please do take advantage of that. Now, the topic of today is a question that I'm seeing, I think we're all seeing asked more and more by employees. And it's the question of them approaching their employer and saying, I would like to relocate abroad, but I would still like to keep working for my employer remotely. Am I permitted to do this? Now, the COVID-19 pandemic has completely changed the way that people work. Remote working has now become commonplace, with many employers now moving towards complete remote working or a hybrid working model. And in the past, there's always been instances where the employer has told an employee or asked an employee to relocate to another location and work from there. But with the change in working pattern, the ability to work remotely, what we're finding now is actually it's employees approaching their employer and saying, I would like to continue working for you. I love working for you, but I would like to work for you from a different jurisdiction. So, for example, the employer might be in the US, but the individual says, my partner's moving to Spain or Germany. I would like to join them there and live there and continue working for you. Whilst on the face of it, this might seem attractive, it does give rise to several considerations and challenges for both the employee and the employer. And today we'll be focusing on the implications of this and these issues with a particular focus on England, Germany, and Italy. So we'll be focusing on those jurisdictions. If you are placing an employee in one of those jurisdictions, what are the things you need to think about? And future webinars will cover other jurisdictions. I'll talk about that at the end. Before we get into the detail of it, I'm going to just give a high-level overview of some of the issues that we think, regardless of jurisdiction, all employers need to think about if they're going to allow us to do this this cross-border remote working. And I've listed them there, and I'll be going through each of them. The first thing an employer needs to think about is local employment rights, because you may have the law of the contract. It may say US law, English law, or whatever it says. But where an employee is based in a certain jurisdiction, that jurisdiction might actually say that if we have an employee based here, and there'll be a test depending on the jurisdiction, they benefit from local employment rights. And what those rights are, whether they benefit or not from those rights, will vary from jurisdiction to jurisdiction. So it's very difficult to have a one-size-fits-all approach to this. And what's important is that often local employment rights, they can overreach and override what's in your employment contract. So you may contract something, but local law might dictate something different. And it could affect lots of different things. For example, it could relate to holiday, severance or redundancy payments, employment protection. It might trigger certain benefits, such as a pension, etc. So it's really important you're well versed in what the laws are in that country to make sure you're not going to fall foul of anything by virtue of these remote working arrangements. The next thing I want to talk about is permanent establishment and tax considerations very briefly. I know the focus of today is employment law, and we will be focusing mainly on employment law, but I think as an employer, you do need to be aware that where you're placing an employee in a different country, or where they are asking to work from a different country, there is a risk that you need to consider that their presence might create a permanent establishment or a taxable presence in that country or jurisdiction. And the rules are determined by the country in which they're based, again, but there are certain sort of key factors you need to think about. The risk generally is greatest where they work from a fixed place of business, such as an office, or if they have the authority to conclude and negotiate contracts or bind that company in any way in that jurisdiction, that increases the risk. And what are the implications of this? Well, there's a risk of double taxation. For example, if there's an establishment that jurisdiction might require that company to pay a certain amount of corporation tax in that. And again, the rules vary per jurisdiction. There are other tax considerations, mainly for senior employees. So if an employee is providing services from that jurisdiction, does that create a VAT risk? For particularly senior employees, particularly those who are directors, could it impact the company's tax residence? For example, if they're attending board meetings remotely from that country rather than the country where the employer is based. And also, if you've taken a loan and that's being used to subsidize that individual's work in that country, could there be a withholding tax risk? So the key really, we're not going into this in detail, but the key really is to ensure that you're getting the right tax advice as well as employment advice when you're placing someone in a different jurisdiction. Now, taking tax, but back to the employee context, of course, employees are usually subject to income tax and some sort of social security or national insurance contribution. And when they're in the same jurisdiction, this is relatively straightforward. You've got a UK-based employer with a UK-based employee. It's quite simple. The employer will make deductions from PAYE and national insurance at source and account to the tax authorities for that. But where the employee is in a different jurisdiction, you have to ask yourself the question, does the tax authorities in that local jurisdiction, so for example, France, if the employee is based in France, will the French tax authorities say, I know the employer is not based in France, but we still require you to register with us and make deductions for tax? Or can you simply place that burden on the employee and say the employee is responsible for making those deductions? In fact, does it go further? Does it require you to actually create or incorporate an entity in that jurisdiction to account for this? And you should also consider whether there's any double tax treaty in place or exemption from social security, such as the A1 form in Europe. And when you're putting together your contract of employment with that employee, it's worth, I think, putting in a tax indemnity so that if there's any failure to account for tax, you're putting that responsibility as far as you can legally on that employee with an indemnity to make sure that they make the employer whole if they haven't done what they're supposed to do. The other thing to think about is immigration. Of course, the employee needs the right to live and work in that jurisdiction where they are being placed. So if they are in the Netherlands, for example, do they have the right to live and work in the Netherlands? Do they need a visa? Because if you don't have a presence there, there may be some sort of bar to you sponsoring that individual. A lot of countries do have a requirement that requires a physical presence for that company to sponsor them. But is there some other way of them getting a visa? Will they get it via their dependent? Again, in the employment contract, do you want to place that responsibility on that employee? And again, it depends on the jurisdiction. But you've also got to think about it the other way. So take a US-based employer with someone based in the Netherlands, for example. Now, the person has the right to live and work in the Netherlands, the employee, but do they have a right to come back to the US and work? Because you as employer might say, well, in July, we need you for a big project. We need you to work in the office for 3 weeks. We'll cover your expenses. But can they get in? And does that visa allow them to live and work in the US or the UK or whatever jurisdiction? So there's that second issue to think about as well. Now, as I mentioned, there's a whole host of local considerations. And naturally, when these issues arise, you get organizations that come in and fill the gap. So what we're seeing is the rise of the professional employer organization or the employer of record. Companies that turn around and say, we have created a presence in lots of jurisdictions. You want an employee to work remotely from a different country? No problem. Come to us. We will take the hassle out of it. We will register with the tax authorities and do the tax. We will we will comply with all the local employment laws. We'll put together an employment contract. You don't need to worry about it. And we will take that administration away from you. And of course, that seems very attractive. But there are consequences and things to think about when you're engaging these companies. Firstly, when they have an employment contract with that employer of record, does that have the same protection you would have as an employer if you were engaging that particular individual directly? So, for example, confidentiality or IP. Secondly, where does the liability lie? So, what if there's some, the employer brings some sort of claim? Is it the case that all that liability is being passed on you as the true employer, or is it on the employer of record? So do take a close look at those contracts to make sure that the liability is being shared out fairly. does that country have a concept of dual employer or real employer? Because they may have an employment contract with their employer of record, but they're being passed on to you, you know, as a consultant or on a secondment basis. Will the court say, well, you're really the employer? Or does that jurisdiction even allow this? And finally, some of the issues that we've raised, you know, are not necessarily dealt with by this employer of record. For example, the immigration issue may not be dealt with. And finally, just to highlight some practical matters, because when they're working across jurisdictions, some things to think about. So public holidays, do they get public holidays in the jurisdiction in which they're based, or do they get public holidays in the jurisdiction in which the employer is based? So for example, US public holidays. What about working time? It's fine when there's a 1 or 2 hour time difference, you might be able to make that work, but where there's 4 or 5 hour time difference, are they working local time or are they working employer time? Your health and safety obligations are likely to extend to employees abroad as well. And I think a really important one is group insurances. So when you say you're going to provide private medical insurance, does your policy allow that individual to be covered from a different jurisdiction, or do they have to get something in that country themselves? So do look at your insurance policies, or are you going to give them an allowance rather than provide private medical directly? So those are the overview issues. I'm now going to hand over to Anna Robinson, who's a partner in our London employment team, and she's going to talk about the issues where an employee is based in the UK. Over to you, Anna.
Thank you, Devan. So the first question to consider, which Devan's already touched upon, is this really key concept as to how the laws of the contract interact with any mandatory rights and protections which the individual might enjoy. It's a simplification just to look at the contract clause. So it might be that you have a Bermudan contract or US law contract, but if the individual is sufficiently closely connected with the UK, then they will enjoy various rights. And in the UK, the two main protections to be aware of are the right not to be unfairly dismissed, which is enshrined in the Employment Rights Act, the central legislative piece of statute we have in the UK, and discrimination protections, which are enshrined in the Equality Act. It's quite a complicated question to answer as to whether somebody has those protections. It's a multifactorial test. But in essence, the types of things you will think about are how many days the person is spending in the UK, where they were recruited from, where they are based with their family, where they pay taxes. Those types of questions will be considered in the round. And I would say if there's any doubts as to whether the individual might have these statutory protections, then of course it's sensible to take UK advice, certainly at the conception stage when negotiating the contract, and equally at any dismissal stage if you, the employer, are proactively moving to dismiss the individual from the business. If the Employment Rights Act is relevant, then it's very important that your contract contains certain mandatory clauses as contained in Section 1 of the ERA. Some of those will be obvious to you, like salary and notice provisions, some of which are less obvious. And so again, if you think that you're caught by the UK, then it's important that you take appropriate advice in terms of what's included in your employment agreement. Just a whistle-stop tour through some of the key provisions and mandatory protections to think about. First of all, in terms of holiday and rest breaks and the like, they're contained in the working time regulations. We do have a 48-hour working week, but it's very common and entirely permissible to opt out of that. But again, it's something that you need to think about when drafting the contract. In terms of annual leave, that will equate to 28 days, including public holidays if you have a full-time employee. National minimum wage needs to be considered. And generally speaking, you're looking at just short of £10.50 per hour. Sick pay, again, there's a statutory sick pay provision to consider. It's around £100 a week. Of course, you might offer more generous provisions in your contract, but that is the minimum entitlement, and the obligation rests on you, the employer, although you can claim back the sick pay through HMRC. In terms of discrimination protection, as contained in the Equality Act, obviously we've got various minimum periods of leave which apply to new parents, but the key areas to be aware of are the right not to be dismissed or discriminated against in any way on the basis of a protected characteristic, which would include gender, age, and disability, for example. The reason why it's very important to be au fait with those rights is because they apply from the very beginning of the employment relationship. There is no minimum period of service which applies before the rights kick in. And in terms of the potential financial exposure for you as a business, there is no cap on the amount of compensation which can be claimed in the employment tribunal. And so these are the types of claims which are potentially very risky and expensive for you as an employer if you have somebody with Equality Act rights in the UK. Notice provisions, again, there are minimum prescribed notice periods. It's generally 1 week per year of service, up to a maximum of 12 weeks. Of course, you might provide for more generous notice. And at termination stage, because of this right not to be unfairly dismissed, which we have in the UK, it's important that your dismissal is fair as a matter of substance, which means that it must be for one of 5 reasons, such as redundancy or misconduct or performance, for example, but it must also be fair as a matter of process and procedure. And that's where I think it's very easy to fall foul of the Employment Rights Act, because we have very particular rules and protocol which must be followed, particularly, I would say, in the context of performance management. If you're dissatisfied with how somebody's performing in the business, but also in the context of redundancy. And we have collective redundancy rules which apply if you have a large number of employees that are provisionally selected for redundancy. So it's important that you take advice at the dismissal stage. Do be aware, though, as I've said already, that even though we have this 2-year qualifying period in the case of most dismissals, in cases of discrimination claims and also whistleblowing claims, where an employee makes a disclosure in the public interest, then those types of claims do not require 2 years service. And as I've said, there is no cap on compensation. Just a brief note on pensions. We do have, or there is this statutory obligation to provide a pension in the UK, and that applies even if you have only 1 employee. It has to be either the government's Nest scheme, or you can provide a private scheme, but the minimum contributions are 3% by the employee and 5% by the employer. Now, it is possible for the employee to opt out of this right, and that can be done at the negotiation stage. But what's not permitted is any suggestion that the employer has forced or induced the individual to opt out. So when you're negotiating these types of benefits at the negotiation stage, do be very careful as to how the correspondence or conversations play out, so there's no later accusation that you've induced the employee to opt out of their statutory right. The opt-out right has to be renewed every 3 years, so it's something that you need to keep on top of and be au fait with. A brief note then on tax, and I'm happy to say one of my tax partners in the London office has joined today, should you have any specific questions on this topic. But essentially, if you have a UK subsidiary registered with Companies House in the UK, then that will always create this obligation to have a payroll facility deducting income tax and social security contributions at source. Equally, if you have a business presence or taxable presence in the UK, then again, there is this obligation to register for PAYE and account for income tax and social security contributions. But if you have a situation in which you're the overseas employer and you have just one person in the UK and there's no taxable presence in the UK, and I think a lot of you will be thinking about that type of scenario when joining this webinar, then it's possible that the employee will be able to account for tax and employee-only national insurance directly to the tax revenues in the UK, His Majesty's Revenue and Customs, through a self-administered scheme. So there might be a way of simplifying the process that doesn't involve payroll or outsourcing payroll, and it might be that you, the employer, is not obligated to make social security contributions. This question as to how employees, perhaps working from home for an overseas employer, are taxed has obviously come into sharp focus, particularly since COVID. And so the Office of Tax Simplification has conducted a consultation looking at this whole question, and our expectation is that there will be reform by HMRC once it turns its attention to it. So it's entirely possible there will be some changes as to how taxation is applied in the circumstances I've described. Just a note on immigration, which of course is more difficult now post-Brexit, because before many employees could benefit from their EEA rights. Now it's quite difficult in practice for non-UK nationals to work in the UK. If you have a business operating and trading in the UK, then you can register as a sponsor with the Home Office, and effectively that gives you a license, an immigration license, which means that you can issue tier 2 visas or work permits, as they used to be known, to non-UK nationals working for you in the UK. But if you don't have an office in the UK, for example, you just have one individual working from their home office, your options are quite limited. And actually, it's important to think more laterally as to what you could potentially rely on. It might be, for example, that the employee's spouse or unmarried partner is British, which means they can piggyback off their right to live and work in the UK with family or personal visas. But the immigration routes are more difficult now. It's fair to say that visa applications take weeks, if not months, to process. And so forward planning is really essential. The other point I wanted to mention is that even though we have what's known as a business visitor visa route in the UK, which is a bit like a tourist visitor visa, which enables people to enter for up to 6 months at a time, that type of visa is really only suitable for business persons entering for perhaps meetings or a bit of training. If they're rolling up their sleeves and engaging in normal work, if I can put it that way, then the business visitor route is not appropriate. And the UK border is very hot on this, and it's entirely possible the individual could either be refused entry, or it might be that somehow they forfeit or prejudice their future rights to make another type of application. And indeed, it might have consequences for you as an employer in terms of fines, etc. So it's really important to understand that route properly and to not misuse it. Another point probably worth mentioning is that if you have somebody with a visa in the UK, but they are globally mobile, if I can put it that way, they're moving across different offices, in an important senior role, for example, then do be aware that if they spend too many days outside of the UK, they can forfeit their UK visa. So it's really important, not just for tax reasons, but also for immigration reasons, to keep an accurate log as to what their days inside and outside of the UK equate to. And of course, that will also assist you in understanding whether they have UK protections under the ERA and the Equality Act, etc., should you be faced with a jurisdictional question at the dismissal stage. And then very finally, because I'm conscious of time, of course, there's a whole myriad of other rights and protections which will apply. A couple to mention, health and safety. It's important that employees, including those working from home, have a safe place of work. Assessments will be required for pregnant employees, disabled employees, for example. Training might be necessary, and it's important to include information on your intranet, for example, as to what health and safety obligations apply. Employee data must be kept securely and not transferred without employee consent and not retained for more than is necessary. And it's important in the UK to have employers' liability insurance, which will provide compensation to the employee in the event of illness or injury caused by work. And that is all I wanted to say. Thank you.
Thanks, Anna, for that. And clearly, there's lots of things to think about. And the one I see quite often is right at the beginning of that relationship. The thing you mentioned about Section 1 of the Employment Rights Act, and employers come and say, "Well, here's a contract. You know, it's in our local jurisdiction. Can we just use that for a UK-based employee?" Well, often, you know, it doesn't work. And actually, in many cases, it's better to start with a UK pro forma because of the differences between.
I would agree with that. Yeah.
I think we see that quite a lot. So thank you for that, Anna. There'll be an opportunity to ask Anna questions at the end. I'm now going to hand over to Nikolaus Krienke from WFW Germany. He's an employment partner in Germany, who'll be giving us the German view. Over to you, Nikolaus.
Hi all. Hi Devan. Thanks for the introduction. And yes, I'm heading the German employment team, and we want to give you certain indications how it works in Germany. And we want to concentrate on certain key messages because Devan mentioned a lot of very important questions you have to assess. And Anna gave a good view about UK perspective, but also conscious of time, I believe it's really important for all of you that you get certain key messages today, that you understand the basics, and the individual questions have to be solved anyhow afterwards. And it's really important that we set a certain foundation for this webinar, because Germany as a EU country has similar issues like other EU countries, because many things are based on EU law. So what I will tell you today is similar to things, or maybe the same, like Giuseppe will later talk about for Italy. And we have the same points also for France, Spain, Greek, when we have our webinar in June. And we concentrated today, in our view, on 3 key issues from Germany. And the first one is we have to differentiate as a red line between EU citizens coming to Germany and non-EU citizens, because completely different rules will apply, what I will tell you later. So that's the first important differentiator. The second one, what is really key is, and it was already mentioned from a UK perspective, is if you're going to Germany, normally the employer will have a certain contractual arrangement with you, what shall apply. And there you have to decide whether you have a choice of law clause in this contract arrangement, whether during this period in Germany, German law will apply, or you say, no, we want explicitly our home state law apply of the foreign company. So this is a second key point. And the third issue we would like to highlight today is social security law. And as a basic rule, German law will apply, and social security contributions have to be made under German law, but there are certain exceptions possible what employees would like, because they prefer not having too many different social security systems applicable to them, maybe even double payments. So yeah, I will skip to the next slide. This is the one with what is the nationality of the employee coming to Germany. So the easier one is EU citizen is coming to work in Germany. This will not require any visas. There's no application process in advance. This EU citizen can work and live in Germany. And if he or she wants to continue to work for a foreign employer, that's completely fine if the employer is fine. So they can take with a family member, with a new girlfriend, boyfriend, an apartment in Hamburg, Germany, and work for Spain or France, whatever they want. So no additional obligations. So it's a very easy one. And the only thing they have to do is to register with registration office in Germany, the Einwohnermeldeamt. This is mandatory, but this is also mandatory for all other German people switching offices and locations in Germany. So nothing special. This has to be done within 3 months after arriving in a German location. And the similar rules apply also for EFTA countries, like they are treated like EU citizens if you're from Iceland, Liechtenstein, Norway, Switzerland. It will become much more difficult if you are from a non-EU, non-EFTA country. It's not that you can say, okay, I believe in Germany, the weather is so nice, I would like to move to Germany, work for my employer from Germany, remote in a hotel room, in an apartment. This is definitely not working. This is not possible. So if you intend to do so, you as an employee need a visa. And the company organizing this has to guarantee that the employee coming to Germany has a visa up front. And there are a lot of different type of visas depending on your specialization, your country you're coming from, your work type. But as a general rule, it's easy to come to Germany if you have a so-called Schengen visa, where you can stay 90 days, not only in Germany, but in the Schengen room. So also in a couple of other, most other EU countries. So this gives you the permission to do this for 90 days. You can do this, but not working. You can do business, but you're not allowed to do work. So you cannot do work from a hotel room, from an apartment, and do the same remote work you did in the US, for example, from Germany. What you can do is meet customers, negotiate a contract, go to a trade form. This is all possible, but not doing real work. And then we have certain exceptions. No visas required for the first 90 days for 62 countries like Brazil, Singapore. So you can come to Germany, do certain like business, like negotiation, meetings, etc., join a trade firm. But again, you're not allowed to work remotely on your home stuff. This is not possible. Then we have a certain exception for best friends countries like US, UK, Japan, Korea, Australia, where you are allowed to come to Germany and you can apply for a permanent visa, not from your home country, like other citizens will be obliged to do so. You can do it in Germany. But unless you have received the visa, you are not allowed to work in Germany for a subsidiary or a branch office or for your home employer. So you have to wait until you get the visa. So it's still recommendable to do this in advance and not come with a visa-free entry to Germany and then apply in Germany. We would strongly recommend to do so in advance. And why is this so important? We get a lot of questions or even projects from larger clients, even during COVID, where they had some issues with visa requirements. And if you are breaching these as an employer in Germany, you face strong consequences. It can be even a criminal offense. You get administrative fines. The employee has to return mandatorily Germany, maybe is not allowed to re-enter afterwards. And what's even most important, you can get a certain entry that you as a company are not deemed any more reliable. And if you receive a second or third entry in this regard, you can be barred from doing business in Germany. So this is something we have to take really serious, that you are in compliance with these visa requirements. And how looks a typical visa? What for our scenario could be the correct one is the so-called intra-corporate transfer visa, this ICT visa. It gives you a chance to employ a person for 3 years in Germany in a branch office or a subsidiary of a group. This is the most likely scenario. So people are deciding, okay, for certain reasons, business-wise or even on a family basis, we want to work in Germany for up to 3 years. We stay employed in our group and we get the chance to do our job in Germany. This requires that you have a certain specialty. You must be a specialist, a higher qualified employee or manager to do so. You have to be employed with the group for 6 months in advance. You need a contract for the whole period you want to stay in Germany. And what's also valid, it must be in more than a 90-day period. So it's not the first 90 days. You can come visa-free, but not allowed to work. It must be a period between 90 days and 3 years. And then you get this ICT visa. That's the most often used form for our scenario. The next key message we want to send is about applicable employment law. So it's really important to decide upfront what you want to agree in the contract. And employees coming to Germany and even sometimes employer tend to agree on the home country law. Say, if you are coming from the US or UK, we want that US law or UK law still applies. It's a little bit to challenge whether this makes sense, because we have by mandatory law, and this is also a EU regulation, you have to still observe, if you have a choice of law clause, certain mandatory elements of German law if the person is working in Germany. And what is mandatory is really broad. So this is annual leave, working hours, safety regulations, health protection, in particular also dismissal protection. And if you have a choice of law clause agreed in your contract, and then also German law applies, you have always to compare what is the more favorable law for the employee. So you have to make a permanent check, is the home country law more favorable or the German law more favorable? And it's not that you compare dismissal protection against dismissal protection. You have to be more specific. For example, what is the dismissal notice period in the US and what is in Germany? So this will cause a lot of administrative burden. So we would, if negotiable with the employee, say during the stay in Germany, we would recommend that German law applies. So if you have no choice of law, anyhow, the complete employment law of Germany will apply. And as Anna said, I would like also to make certain highlight comments regarding German dismissal protection law, because people always feel it's so difficult to dismiss people in Germany. It's high thresholds. They have 3 main reasons you can dismiss an employee. The first one is an employee is breaching, after warning letters, again and again, certain employment duties. So this will be a dismissal for misbehavior. The second one is the personal reasons. For example, an employee is long-term ill. You have a negative prognosis for the future that this employee will become fit to work again. And the third one is this operational business reasons. You want to downsize the company, a business operation, and you make people redundant. This is a valid qualification to dismiss, but you have to make a so-called social selection between employees regarding age, length of service, dependent family members, who is the one who you can dismiss. And this is always applicable only in business operation with more than 10 employees. So if you send a person to Germany to a small business operation below 10 employees, this will not apply at all. So you have, as an employer, the good possibility to dismiss basically unless there's any arbitrary behavior of the employer, or you dismiss without any relevant motives. So if you dismiss an employee because he's claiming his vacation days, or you dismiss an employee because of he or she is gay, this would all be, of course, invalid. But otherwise, if you don't give any real reason, just saying, I believe your performance is not good enough, I want to dismiss you, this is possible, these small business operations in Germany. I think this is noteworthy to know. And the last point I would like to make today is about Social Security law. Like I said at the beginning, we have the basic rule: if you are working in Germany, the Social Security laws of Germany apply, and you have to pay the Social Security contributions. They are rather high in Germany. The employer is paying on top of the gross remuneration of the employee 20%. And again, the employee has to pay approximately, again, 20% of his gross salary. So in total, it's a little bit more than 40%. This is rather high, at least compared to many other countries. And so there are certain exceptions for EU citizens. The first one is if you're living in Germany, but you're not spending all the time in Germany because you're traveling a lot to other EU countries, for example. You are less than 25% in Germany during the working week, not only the weekend and maybe on a Friday in Germany, then you can apply for an exception. But I mean, most people, if they are in Germany living, they are more than 25% of the working week in Germany. So you have a second chance to apply for an exception. This is by this so-called A1 certificate. And if you are not more than 2 years in Germany, EU citizens and EFTA citizens can apply for this A1 certificate, because the intention is that they keep their social security system from the home country and home employer, and that they don't have two permanently. And the third option is for people working 2 to 5 years in Germany, and they have to make a more complicated exception application process. They need also this A1 certificate, and then there has to be an agreement between the central associations of social insurance, between their homeland, like say, for example, Spain and Germany. They have to come to an agreement, and the employee has to agree. Most justifications are, I have already certain pension schemes in my home country, and I don't want to have for a couple of years the Spanish pension, and then for, let's say, 4 years a German pension claim against the German state. This is a valid exemption reasoning. And the last point I want to make for today from Germany is how do we deal with non-EU citizens. There we have to look very in detail whether there are bilateral agreements between Germany and this foreign state, non-EU state. And then you have to look in if this agreement exists, whether they have an exception. And it's interesting that they don't have always exception for all social security branches. We have like pension, health insurance, elderly care, accident insurance, all these social security branches in Germany. With certain states or countries, you have only exception for health or only for pensions. So you have to look at the details, and there you have to apply if you want for this exception with the consent of the employee. Yeah, this is a high overview from Germany, and I give back to my colleague Devan and then to Giuseppe from Italy. Thank you.
Yeah, thank you, Nikolaus, for that. And again, sort of noticing sort of the differences between the UK and Germany, and what sort of stood out for me was this choice of law clause was so important, because you could find yourself in a really complicated situation where you're getting the worst of both worlds if you're not smart about how you approach that. So it's really important to think about that, because that's right at the beginning where you think about it, and often the consequences might be later on when you're dismissing or later on in the employment, but it's very important to do that right at the beginning. So thank you for that, Nikolaus. Before I hand over to Giuseppe, just a reminder that there is the Q&A function at the bottom of the screen, so please do submit any questions via that, and please do give your name. I'm now going to hand over to Giuseppe Bulgarini, employment partner from our WFW Italy, who'll be giving the view from Italy. Over to you, Giuseppe. Thank you.
Thanks to you very much, Devan, and it was very interesting to hear as well Anna and Nikolaus on the German side. I will try to give a different perspective. Moving to our question. Okay, moving to our question, we have to keep in mind, under an Italian perspective, that we have three conditions to be taken care of. First of all, we have a foreign employee. Second condition, the employee is performing his duties remotely. Third condition, the employees continue to perform the business abroad. So it's not a question of having an employee in Italy to run the business of the company in Italy. The company is not going to set up a business in Italy, nor is going to continue a business in Italy. We are in a case where the employee has asked to move to Italy, and therefore he will perform his duties remotely. This allows us and implies that we have to take care of law number 831/2017, which is a law regulating remote work. In Italy, we have a specific legislation providing compulsory rules which have to be followed, and in our case must be taken care of by the employer. We have, so first of all, the employer must guarantee the right of disconnection to the employee. It means that since the employee is working remotely, we assume that the performance of the activity is mainly done through electronic tools, and this connection must safeguard the right of the employee not to be in touch with the employer and with the business organization of the employer for a period of time. And this means that the employee must be disconnected from the electronic tools. Normally, what we do in Italy is that the period of disconnection, which is a daily disconnection, will be coincident with the 11 hours rest compulsory per day. In between one working day and the second working day, according to Italian laws, employees must have 11 hours continued rest. Therefore, disconnection should include the 11 hours period. Second, minimum mandatory rule which employers should follow since the employee is working remotely are communicate general and specific measures to safeguard health of the employee and prevent accident at work. So just to give you 3 examples, employer should communicate in the written communication that employee can, of course, move from a seat to another site to another seat when he is working remotely, but he should not use, for instance, motorbikes, bicycles, or whatever other instrument to move, which is considered dangerous. Second issue, which we could explain. Of course, the employee is on a remote work activity, therefore he can choose where to work from, according to Italian remote working law. But the communication should specify that employee cannot perform his duties in seats or in areas where there could be a risk affecting himself, but also creating prejudice or affection for the confidentiality of data and information which are kept in the personal computer or in the other belongings which are used to perform the duties. Third case we can give as an example is in the communication, it must be specified that employees have to work in a space where illumination is made in a way that is safeguarded the health of the eyes, or that an ergonomic seat is used. Then we have, these are just examples. Moving further, it's very important to have a policy, or at least to provide written individual communications to the employee and instruction on the proper use of electronic devices. This for two main reasons. First reason is that employer has to will have information and data which are retained due to the use of the electronic devices. Emails are exchanged between the employee working remotely in Italy and the business organization of the employer, let's say abroad in Germany, in England, or in the US. Very good. Also, the employer will have to verify if this connection has been materially fulfilled by the employee, as we said previously. Therefore, he will verify that the employee has signed off from from Microsoft Teams, or that he has fulfilled the alarm clock and switched off the computer. All these are controls which are made by the employer through the use of the electronic tools. And in Italy, we have a very strict regulation in the statutes of workers, which does not allow to control remotely the activity of the employees unless there are specific scopes which are to be protected, such as avoid that there could be intrusion on the computer by external organization, provide cybersecurity protections, or even safeguard the company against an illicit behavior or criminal, possible criminal sanctions, which could be held due to the activity that is performed remotely. This implies that the policy, the communication to the employee should indicate carefully that the employee can use the electronic devices and tools only to perform his duties, that it is absolutely forbidden to use for personal purposes the electronic belongings, or if authorization to personal use is added, then this should be delimited carefully. For instance, you should indicate in the policy that the employee cannot install application without previous written authorization of the employer. So this leads to the use of electronic devices as well, because use of electronic devices is also the way throughout the employer can send instructions and supervise and control the activity which is daily performed by the employee. And since we are on a remote modality, there is no presence. And so as to keep a connection, we should indicate which are the modalities through which lawfully the employer will instruct the employee, interact with the employee, and control the performance of his activity on a lawful perspective. Therefore, just give you two examples. We normally indicate that on a weekly basis or on a monthly basis, the employee will send a report with the activities he has done and with the activities he will do the following week. Also, you could prepare and have some chats on the internet, such as WhatsApp or Teams, which are groups, closed group, to which only the employee and the other employees working abroad of the department will connect. And you can indicate that the employee has to connect whenever it's requested to the chat group, has to receive instructions and has to share information. Second, mandatory rules which should be kept into consideration are working hours restrictions. Therefore, as also Nikolaus has said previously, normally we have a maximum 48 working hours per week in Italy, including overtime. Overtime should not exceed 2 hours per day. The maximum 48 working hours is to be considered on an average period of 4 months, but national collective labor agreements could also enlarge this average period to 6 months. In any case, if we are on our question where the employee is working under the foreign country employment contract of the employer, we will not have a national collective labor agreement applied. So we would refer to the 4-month average period. As I previously said, 11 continued hours of rest in between one workday and the other workday. Also, 24 continued hours of rest per week. This means that in Italy, employees have to rest for a period of 1.5 days, because we have to match together the 11 continued rest hours per day and the 24 hours rest per week. Also to be considered that if you work on a monitor, and this would be the case of a remote employee, remote working employee, 15 minutes of rest after 2 hours at the monitor. Finally, minimum 4 weeks of holidays. I see that in Germany and especially in England on Anna's presentation, weeks of holidays are higher. In Italy, it's 4 week minimum compulsory, but also in this case, national collective labor agreements often provide for a longer period. Just to give you also a quick overview on dismissals. As it is in all other, at least EU countries, dismissals are to be considered in 2 areas. Dismissal due to subjective reasons, therefore disciplinary dismissals, and dismissals related to the business, so organizational and or economic reasons. In the first case, the employer has to follow a specific procedure which is regulated by the statutory worker, which implies that the employee has a specific time period to provide written and or verbal justification on the claim which have been notified against him by the employer. If the procedure is not fulfilled, in some cases, the dismissal could also be to lead to reinstatement, just in some cases. I will not detail on this, but instead I will focus on dismissal for organizational economic reasons. Also in this case, we have a procedure. I am speaking of individual dismissal, and I will not speak on collective redundancies, since we are in a case where an employee, a single employee, moves to Italy. So you need to fulfill a specific procedure which implies a meeting at the local employment office if the company has, as in our case, we can say, more than 60 employees overall, of course, considering the employees of the foreign employer. Due to the fact that, according to recent Italian case law, as to verify the number of the employees, you have to consider also the employees working in other jurisdiction if the employees performs his work exclusively or also for the foreign employer seated in a different jurisdiction. What the procedure says? The procedure says that the employees has to send to the employee a written letter detailing the reasons for the dismissal. Then a meeting will take place as to verify if it is possible for the employer to avoid the dismissal by, for instance, assigning the employee different duties, or to find a mutual settlement where the employment is terminated and the employee is paid a fair indemnity to leave. Very quickly, consequences deriving from dismissals in case of an unlawful dismissal. If the court ascertains that the dismissal was a discriminatory measure or has been adopted as a retaliatory measure against the employee who had exercised a right, then reinstatement and full economic indemnity will be covered by the employer. Full economic indemnity means that the employer has to pay the full remuneration in between the date of the dismissal and the date of the reinstatement. Moreover, the employee has the right to substitute the reinstatement with the payment of additional 15 overall gross monthly salary. Then we have the cases of unlawful dismissal. We have 2 different cases. fully inconsistent reasons based on dismissal, disciplinary dismissal, or dismissal for economic reason. In this case, you would have reinstatement and economic indemnity up to a maximum of 12 monthly salaries. In the other cases, instead of unlawful dismissal, you have only an economic indemnity protection, and the economic indemnity protection varies depending on the numbers of the business, but we have considered, as I said previously, only the case where the employer has more than 60 employees overall. And in this case, if the employee was hired before 7 March 2015, you will apply for the statutes of worker economic indemnities, which is minimum 12, maximum 24 overall gross monthly salary. Instead, if you are hired from 7 March 2015 over, statutes of workers does not apply anymore in Italy, but employees are entitled to a reinstatement which could arrive up to 36 overall gross monthly salary. Just 2 minutes on these last two issues, which are social security and tax issues, because Nikolaus has covered them very well. And so I will just tell you that mainly if we have an employer which is an employer based in an EU company, you have two different possibilities. If you second the employee to Italy, but I would see no interest on practical point to second the employee to Italy, since you're not going to establish a permanent organization or to run any business in Italy, but the employee is only working for his personal needs in Italy, but performing in his country of origin, then in this case, anyhow, social security position can remain with the employer if the duration does not exceed 24 months and the employee is not seconded to substitute other employees. So I would concentrate more on the first scenario if we only speak of a remote employee in Italy based on his personal needs. The employer would open a social security position in Italy, including compulsory health insurance to protect health against accidents at work. In this case, legal representative of the employer needs a tax code. Moreover, the company has to be availed, has to have a tax code, and every month social security payments which are linked to the remuneration which is paid to the employee by the foreign employer according to the foreign employment contract have to be paid monthly throughout a so-called F24 model. Practically, in Italy, what happens is that the foreign employer would appoint a payroll consultant or a tax consultant to provide those payments monthly. And so if you are extra aware, I would not speak on this. Nikolaus has already provided evidence that if you're not EU or you're not an EFTA country, what happens is that you have to verify according to specific agreements in between the countries as to avoid double contribution payments or to face how to properly manage double contribution payments. Finally, Italian tax law. According to Italian law, but this is similar in all EU countries, if the employee works in Italy for at least 183 days, he is considered tax resident in Italy. Moreover, and more specifically, you are considered tax resident in Italy if the employee is enrolled in the registry of the resident population in Italy, or he is domiciled in Italy. It means he has an interest in Italy. For instance, he has his family in Italy, or he has opened his residency, he's resident in Italy. In all these three cases, if 183 days are met under one of these three conditions, the income tax have to be paid in full in Italy. Okay. Also, if some activities are performed abroad. In the opposite case, if less than 180 days per fiscal years are worked in Italy by the remote working employee, income tax will be paid in Italy only with reference to the work days in Italy. The Italian legislation, which I have just roughly described, must be matched with agreements which Italy has entered into with European countries and with non-European countries. So I have finished my presentation, and I give back to Devan the speaking. Thank you very much.
Thank you, Giuseppe, for that. And what stood out for me, again, from as a UK-based employment lawyer, was this right to disconnect. And I can see this becoming more and more of an issue, particularly with mental health and employees, working remotely. That when do you switch off? When do you cut off? And it's interesting, obviously, that you've got that legislation there in Italy, which deals with that. And in fact, we've had a question on it. So just to quickly wrap up some key points before we move on to the Q&A. So even within Europe, it's clear that there are key matters such as termination that vary by jurisdiction. So it's really important to understand what the rules are in that jurisdiction. And as an employer, you may be keen to accommodate your employees, but you should exercise some caution, because there might be some unintended risks and consequences for you as an employer that you weren't anticipating. And so from that perspective, we recommend putting in place some sort of overseas working policy, so that it's not just simply up to the employee, or it's always at the discretion of the employer, because you as an employer may get comfortable with certain jurisdictions, but with other jurisdictions, you may want to examine it a little bit more, or have the right to say no, because the consequences for you are too high. But so I'd like to thank all the speakers for their contribution today. We are over in terms of time, but as speakers, we are happy to sort of stay on the line for a little bit longer to answer some of the questions we've had. Just a reminder, if you have put some questions in the Q&A tab, if you haven't put your name, please do put your name, because if we don't get to all the questions, we can come back to you separately afterwards. I appreciate, obviously, some of you, if everyone's more than welcome to stay. Some of you may need to drop off, which is of course okay to do so. So before we go to the Q&A, just a reminder about our future webinars. We've got one on the 17th of May. I'll be giving the overview, and we'll be talking about the UAE, Vietnam, Singapore, and Australia. Slightly earlier start for us in Europe on that one. And then our final webinar in the series on the 14th of June, where again, after the overview, we'll be talking about France, Spain, and Greece. So, do join us for those. And also, just to mention, you will receive a feedback form. Please do complete them. Okay, so now moving on to the Q&A for those of you who can stay with us. We've had a couple of questions. The first one is for Nikolaus, and it says, if in Germany only very limited dismissal protection applies in a small business, could an option be for a foreign employer to actually transfer their employee to Germany to try and get around the rules and effectively terminate them a little bit more easily? Is it possible to do that?
Yeah, that's a good question, or a smart question. I mean, logically, from a legal perspective, this could be an option, but if you do this intentionally and a plant just sending a person to Germany to make use that they are not really just protected against dismissal in small business operations, this would probably be deemed arbitrarily to circumvent certain rules. So I would not advise to do so, and probably the administrative burden to relocate a person to Germany just to get the benefit to dismiss him or her easier is probably not worse. And also you need the consent. I mean, no employee will be relocated against his or her will to Germany, and if the employment relationship is already so tense, probably they will not accept it. So I would say logically a good idea, but practically probably not working. Yeah, this is my advice. And I have seen some Q&A questions already here on the sheet, and I answered some of them directly with short answers. So if you want a more specific answer, of course, feel free to send another email or get in touch with us.
Absolutely. So, either by the Q&A tab, or the speakers will be available as well to answer questions afterwards. Do get in touch. Our contact details on the slides. We've actually, as we anticipate there might be, we've got a UK tax question. I'd like to introduce our UK tax partner, Claire Miles. Hello, Claire. Thank you for joining us. The question is, can an employee working from a home office or hotel constitute a permanent establishment? So Claire, over to you on that one.
Good question. That comes up quite often, and obviously that was a really hot topic during the pandemic when we had lots of people working from home. And I think the first question is, people often jump to saying, is it a permanent establishment? But is that the right test? And that will be the right test usually if there's a relevant double tax treaty, but there isn't always one. If you have an offshore employer and an individual, say, working in the UK from a Bermudan company, they only actually have to be carrying on part of the trade in the UK in order for that to be a taxable part of the business. But anyway, but in most scenarios that we're dealing with, it's a company, say in Europe, we've got a double tax treaty. Is there a PE? Generally, there shouldn't be, but you can't give a general answer to all scenarios. Always important to check the fact pattern, and things to consider are whether or not there's an office from the employer that is made available to the employee, but they're just choosing not to use it, or if the employer is requiring them to work from home. That more suggests that their home is sort of at the disposal of the employer or made available. Another question is whether or not that work that's being carried on is like a continuous trade that would constitute a PE. For example, a hotel room rented by a day or by the week isn't going to be a sort of continuous geographical location where the business of the company is carried on, so that shouldn't usually constitute a PE. And then the final thing is whether or not the activities of the individual are important enough to really constitute the core trading function of that company. And, a lot of individuals, they're working in part of the business, but the work that they're doing is preparatory or auxiliary. It's just sort of an add-on or a back office function to the more important work that's being carried on by other people. So you don't have to worry so much about those sorts of functions. But of course, that assumption can be displaced if you have a very senior manager or a salesperson carrying on, the kind of core selling, value-adding functions of the business, in a different location from where the company is headquartered, then, that is a risk that can constitute a PE. So I think, the general answer is no, it shouldn't. But it's really important to take advice on what the fact pattern is and to make sure that the advisor really understands the business and also understands the function that particular individual is carrying on when they're working from home or working from a hotel.
Thank you, Claire. I'm glad you joined us because that's definitely outside of my comfort zone. And I think the point to emphasize here is there's always a tax consideration. It really is, particularly, when you're senior employee, sales employee, you really need to get some advice on that and make sure that that's not going to trigger, a cost for you as an employer, because that would, you can't necessarily deal with that in the employment contract by way of indemnities. That is something that would sit with you as the employer. So it's really important to be mindful of that. Okay, just a couple more questions. So Giuseppe, we've had a question for you. What can an employer do to secure that the remote employee disconnects from their electronic devices? And what can the employer do if the remote working employee does not respect that obligation to disconnect? So very briefly, Giuseppe, if you could touch on that. Thank you.
Very briefly, what can the employer do if the employee does not fulfill the obligation to disconnect, such as other obligation he has to fulfill since he is working remotely? The letter should indicate that the employee does not disconnect. Not only he would be subject to a disciplinary action because he's breaching with a substantial obligation deriving not only from the contract but from the compulsory laws of Italy. He could be revoked the possibility to work remotely. I mean, if we were in Italy and we are using very much, we call it smart working, which is agile work. You work from home 2 or 3 days, so remotely, and you are in office the rest part of the time. If you do not respect this connection, the employer will immediately revoke your possibility to work remotely. So I would use the same regulation in our case.
Thank you, Giuseppe. And we are sort of 15 minutes over. We've had a few questions in the Q&A tab that we haven't answered. If you've given your name, we will come back to you. One, I just wanted to, rather than go to the speakers, just to quickly deal with one. Someone asked about statutory holiday in Germany, but what's the norm? 28 to 30 days is a norm, Nikolaus has said. And the other one is about business visits. You can enter for business meetings into Germany or training without a visa, and the same with the UK. But it depends on the for the UK, it depends on the nationality, because some people can enter without a visit visa. Some people do need a visit visa, and I think the same is for Germany if you qualify for Schengen, etc. Apologies, we've not had a chance to get to all the questions. But we will, as I said, come back to those who have submitted questions afterwards. I'd like to thank you all very much for joining us today. We hope you found it a really informative session. And you've got all the contact details on the slides for the speakers, and you will be receiving the slides, those of you who have registered for today. If you haven't registered or didn't or dialed in, then please do email our events team so we have your details. We can send that to you. So thank you very much, and thank you to all our speakers today for joining us and giving their insight. I found it really interesting to hear about the different the differences in all the jurisdictions, even within Europe itself. So thank you all. Thank you very much.
Thank you very much.
Thank you.
Bye. Bye-bye.
Bye.